It is your testimony that you reviewed this entire case that included the vial of blood and liver tissue from the baby, from the fetus, as well as a homogeneous container in less than 55 minutes?
Yes.
Is that possible, Dr. Midthun?
She's painting the word beautiful on a canvas at 9:10 in the evening. 19 minutes later, she can't form words on a phone call, and by 9:50, she has no pulse. That is the window the prosecution is asking a jury to accept as an unexplained overdose. The defense has a different theory. And what happened in the middle of this courtroom, before the jury was ever allowed back in the room, is the reason this case may never be the same. Welcome to Verdict Decoded. What you're about to watch is not a meltdown, not a confession, and not a dramatic movie moment. It is something rarer. It is a judge quietly pulling the thread on a prosecution's evidence chain until the whole thing nearly came apart in real time. The case centers on Jade Benning, a pregnant woman who collapsed at home and arrived at Vanderbilt University Medical Center with a cocaine level that one forensic pathologist described as unlike anything she had seen across more than 3,000 autopsies. The prosecution's cause of death is acute cocaine toxicity. The manner of death, according to the medical examiner who performed the autopsy, could not be determined, meaning the circumstances were suspicious enough to stop short of ruling it an accident, but not conclusive enough to call it a homicide. That distinction matters more than it might seem. Before the jury even saw the first witness, the defense raised an objection that stopped the entire proceeding. Their argument was straightforward and genuinely difficult to dismiss. Nobody had testified that the vial of blood used to determine how Jade Benning died was actually Jade Benning's blood.
Yes, Your Honor. And like Dr. Carney's testimony this morning, I'm assuming that the state is going to call Dr. Carney as we broke yesterday. That was the assertion. We'd like to address the vial of blood that Dr. Carney relied on in coming to her findings as a result of the cause of death for Ms. Benning. There is an issue with the chain of custody for that vial of blood in regards to the identity and integrity of that vial of blood, meaning that there is no witness thus far that has come to testify that the vial of blood labeled MEC 23-0842 for Jade Benning is in fact the blood of Ms. Jade Benning, because Dr. Carney was not the one who drew that blood and placed it in that vial of blood that she has relied on in determining the cause of death. So we wanted to address that with the court before the witness got on the stand.
Think about what that means. The whole case runs through a single hospital blood sample drawn on the night she arrived. That sample left the hospital, traveled to the medical examiner's office, moved to a toxicology lab in Pennsylvania, came back, and was photographed and preserved. But nobody who drew it was there. Nobody who transported it was there. Nobody who labeled it was there. And the medical examiner who relied on it to determine cause of death readily admitted, under calm but methodical cross-examination, that she did not know who drew the blood, how it was transported, what day it arrived at her office, or who applied the identifying label.
Good morning, Dr. Carney.
Good morning.
It is good to see you again. I want to ask you a few questions. If you remember, I'm Letitia Quinones-Hollins. I want to ask you a few questions in regards to State's Exhibit number 12.
Okay.
Who drew the blood? Who drew that vial of blood in State's Exhibit number 12 on 2/25/23 at 22:31?
I don't know the actual person who drew it, but it was drawn, at the hospital when she came into the emergency department.
And so it was not you who drew that blood?
No.
Okay. Who then took the blood that was drawn purportedly from Ms. Benning? What did they do with it at that point?
I would appear they sent it to the chemistry lab because that's where my transport service, they picked it up from the chemistry lab.
Okay. Who took it to the chemistry lab?
I don't know.
And when it got to the chemistry lab, can you tell me what day it got to the chemistry lab?
I would assume it got to the chemistry lab very quickly after so that they could run whatever tests the doctor ordered.
But can you tell us the date that it got to the chemistry lab?
I don't have that right here.
And on what date and at what time was it picked up from the chemistry chemistry lab to bring to you?
Have that here. Not sure if I have that documentation exactly what date and time it arrived at my office. I don't see that here. I don't see that here.
Who would have
Probably be, there is a logbook at my office. And it would be in the logbook when it actually arrived. And I don't have a copy of that in my records here.
it? Can you get someone to find that out?
Sure.
Any other questions?
Yes. And I understand once you get the log, you'll be able to tell us when it arrived at your office. But can you tell us when exactly it was picked up from Vanderbilt?
Well, it should have been the same day. It comes directly from the hospital to our office.
But is there anyone that you can tell us who can actually testify to that?
I'll have to look at the logbook and see if I can find out who transported it.
Who put the labeling Jade Benning with the medical number of MEC 23-0842 on this vial of blood? In other words, who affixed the labeling of this vial of blood?
Objection, Your Honor, to be relevant.
Well, do you know?
I'm not sure if that was us or if that was NMS Labs.
You're talking about the photos when you got it back.
Right, so this label that's separate from the tube, that's my office label. The tube, the label that's, yeah, this one, this is just the hospital label that's on the tube. And then this is my label at the office.
And then when you got it back,
So when we got it back, this is, the paper label is from my office. And then this label, I'm not sure if this is all one sticker, and if it is, then that might be the NMS Labs label.
And I guess my question is, when this vial of blood was labeled to belong to Ms. Benning, who did that?
We identified it as Miss Benning's blood at our office and would have sent it as such. And it gets packaged in a way that it's usually enclosed so that it can't be broken open and
Yes, ma'am, I understand.
altered.
But before it got to you, someone had to label that it was in fact Ms. Benning's blood.
Right. There's a stat name that belongs to her.
Right. Who did that?
So she got her stat name at the hospital.
No, ma'am. Who identified it? Who put the labeling on this vial of blood so that we would know it is in fact Ms. Benning's blood?
I would assume whoever drew it from her, that's their responsibility to identify her and label
talking
it.
about Vanderbilt.
Right.
Okay.
And do you know who that person is?
No.
What method did they use to obtain the blood?
I wasn't there. I don't know.
And how much blood did they actually draw from the beginning, from Ms. Benning?
I I don't know how much there was from the beginning. I know how much there was when it came to me, because that's in the report.
And so, just so that we're clear, you don't know who drew the blood?
No.
Don't know what procedures were taken?
We've heard all of that. Do you have any other new questions?
The judge's response to all of this was not loud. It almost never is when a judge is at their most effective. He looked at the prosecutor and asked one question.
That it is what it is.
Well, Dr.
Are you willing to risk this case on whether you've shown that?
Are you willing to risk this case on whether you've shown that? The prosecutor said no.
As we all know, I have to be able to assure reasonable assurance that it is what it is.
Well, Dr.
Are you willing to risk this case on whether you've shown that? Okay.
Again, the state submits that we've met the preponderance of the evidence. It's in the
Well,
medical
show me
records.
something in the medical records that helps the chain of custody.
It's on page 65 and 66, where the blood was collected at 22:31, and we have the exhibit that Dr. Olusoga.
And just like that, the entire morning schedule collapsed, witnesses were reordered, and a forensic toxicologist who had nothing to do with the original plan was suddenly first on the stand. Here is where it gets interesting in ways that go beyond this courtroom. Everyone who has ever worked on a project knows what it feels like to hand something off and assume the next person handled it. You write the email and assume it was read. You ship the product and assume it arrived. The entire American evidence system is built on the insight that that assumption is never enough. Chain of custody is not bureaucratic paranoia. It is the institutional memory of every object that matters. When it breaks down, what you have is not evidence. What you have is a story. The defense did not stop with the chain of custody. Their second target was a toxicologist named Dr. Midthun, who had been assigned to produce an independent corrected review of the original lab findings.
Now, to be clear, how it was obtained from Ms. Benning at Vanderbilt Hospital, you have no knowledge of, is that correct?
Correct.
How it arrived at the medical examiner's office, you have no knowledge of.
Correct.
And how it left the medical examiner's office and then arrived at NMS, you have no knowledge of.
Only that we received it through FedEx courier.
Okay. And you received it on April the 4th?
Correct.
And that's 2023?
Correct.
And you did not perform the original testing, correct?
Correct.
Under cross-examination, the defense established something that the courtroom heard very clearly, even if the scientific language softened it. The request assigning her to the case came in at 2:02 in the afternoon. Her report was signed at 300. The data package she was reviewing was, by her own acknowledgement, likely close to 2,000 pages.
I have no idea. It's a lot. So on top of just the case, these runs are performed with quality control samples, with calibration samples to help determine the quantitation. So each run can be hundreds of pages long, and this sample had several runs because of the repeat testing. So I'm not exactly sure how large that file was. It was likely hundreds of pages, if not over 1,000 pages.
Would you trust me if I tell you that it was 1,912 pages?
That would not surprise me.
The defense asked the obvious question. She confirmed that yes, she had done her case-level review in approximately 53 minutes.
Yes.
Is that possible, Dr. Midthun?
Yes. From our experience and training, we are trained to do this review, this case review. I review thousands of cases a year. So I am trained to very specifically be able to look through, determine the data, look at the accuracy of the data, review and suss out that the runs were performed properly, that I see no concerns or issues. So it is certainly possible. It was 2 samples. I was aware of these cases and have been aware of these cases for quite some time due to the length of preparation. So I can't recall if I had looked at some of the data previously or not, but it's certainly possible there as well. So I did and was able to go back in and re-review it in approximately an hour.
Well,
And that may be just the date and time stamp of the message from the communication technician that wrote that in the communication log. I don't know when the actual communication request came in. They may have given me a heads up earlier. This is just when she recorded it in the communication log. So to be fair there, it's unclear if that timing is exact to a phone call or email, or just when they logged it into the system that we received this request.
She was composed, credentialed, and confident in her explanation. She reviews thousands of cases a year. She is trained for efficiency. The system has multiple layers of review before it ever reaches her. All of that may be true. But the defense had already gotten what they needed from the exchange. Not a concession of wrongdoing. Something more powerful. A picture of how much trust is embedded in the word independent.
but before you can actually rely on the findings of this test, the person who is analyzing this must do exactly what you just detailed, right? They must look at every sample in order to determine that the batch is good, correct?
Yes.
And you looked at the summary, not each individual one.
I can say I did not physically look at every single QC for these samples.
And in order to come to a reliable decision, you do have to make sure that each individual QC is done correctly.
The judge ultimately allowed the evidence in.
All right, in terms of the chain of custody issue and the blood, we have to go back to Dr. Olashoga, who he was unclear what Exhibit 12 was, which makes sense because it hadn't even been, that photo hadn't even been made when he was involved in the case, but he did say that the blood was taken from who they labeled as the stat patient. And then the date, etc. That the blood was taken. The hospital records show that, and the state doesn't have to show every runner that touched it or every person that touched it in the chain, but to give the court reasonable assurance that we're talking about the same vial of blood. The defense attorney cross-examined until the jury goes to sleep about whether or not this landed us here today an accurate result. But in the court's opinion, and the case law sets out the language, identity, intangible, the identity and authenticity of the piece of evidence does not have to be proven beyond all possibility. Without all possibility of tampering need not be included. Just reasonable assurance that this is the same blood. There's no question it is in the court's mind. In terms of the Dr. Midthun and whether she can testify about her findings, she's gone into great detail about hers is a higher level of overview. Extra analysis is performed. And again, she's here as a witness to be cross-examined. It's not a surrogate situation like Smith versus Arizona. It's more like the Hutchison case here in the state of Tennessee found that the medical examiner's report wasn't even testimonial because of the primary purpose for that being done. Here, they're trying to determine whether there is any kind of substance that would cause the death, just like a medical examiner would be doing. But in terms of violating Mr. Taylor's right to cross-examine witnesses, there is a witness here. Apparently, Ms. Holland's question, she's got all kinds of proof how this isn't reliable based on her interview with Dr. Midthun. So I do not find there's a constitutional violation preventing Dr. Midthun.
He ruled that the chain of custody met the legal standard of reasonable assurance, not proof beyond all doubt, and that Dr. Midthun was not a surrogate witness in the legal sense, but a scientist offering her own opinion. The prosecution had done enough. Barely. But that is exactly the kind of ruling that defense attorneys build appeals around, and that juries carry into deliberation rooms without fully realizing they are doing so. The question in a courtroom is never whether evidence is perfect. The question is whether the doubt it creates is reasonable, and this judge just told the jury, in effect, that the gap exists. He just decided it was not wide enough to exclude the blood entirely. The jury will now hear from witnesses who will paint a specific picture of Jade Benning's final 40 minutes. Painting words on a canvas, losing the ability to speak, becoming pulseless before anyone understood what had happened to her. The toxicology is damning.
Able to paint words on a photo at 9:10 p.m. and at 9:24 p.m. She's been painting, and the word beautiful is now added to the photograph. It's been painted. The words are legible, you can see them. If that happens between 9:10 and 9:24, and then there's 4 minutes of photographs taken where you can't really tell anything about symptoms. But then 19 minutes from that kind of first painting, she's added words at 9:24, and then at 9:29 p.m., there's a phone call where someone describes Ms. Benning as being able to talk at the beginning of the 6-minute call, but by the end of the 6-minute call, her words do not form and make any sense. And then she is found by EMTs within 20 minutes of that, and she is pulseless. That time frame, is that consistent with her ingesting that cocaine within 30 minutes of her being found pulseless?
The cocaine level found in her blood, estimated by adding the parent compound to its breakdown product, came out to nearly 8,000 nanograms per milliliter. A typical acute cocaine overdose in the medical examiner's experience runs under 1,000.
And that first time that we met, had you ever seen anything close to that level? I could not recall anything this high. What would a typical level be in a overdose where it's just cocaine, no other substances, that you were familiar with from your career of the cases? So I'm going back over the acute cocaine intoxications, and they're pretty much all under 1,000 nanograms per milliliter. 2 or 3 were in the 1,000 to 2,000 range. And since that first meeting that we have, did you do another review looking for anything that compared to this particular result? I did go back through looking at all of my acute cocaine intoxications, really trying to look at those carefully. I even looked at dozens of the ones that had cocaine plus other drugs involved. And did you find anything that was similar to that amount of 78 nanograms per milliliter? I found one.
She had seen one other case even close to this number in her entire career.
The method, or can you just describe the circumstances of that particular case? That one was believed to be ingestion. It was someone who had been taken into custody, was believed to have swallowed something while in intake at the detention center, and then died during the booking process. And when you say died during the booking process, what was the amount of time? And if you said they ingested it, how did they ingest it? Swallowed. So it was an oral ingestion. Do you know an approximate time frame? I don't, but it did not sound like it was a very long period of time.
That case involved someone who swallowed cocaine in a detention center during intake. The prosecution says someone gave Jade Benning liquid cocaine without her knowledge.
Dr. Carney, did you determine the manner of death?
Yes,
And what was the manner of death?
could not be determined.
And you did not make a determination on that, correct?
Correct. The circumstances surrounding her ingestion of cocaine were very concerning, that she ingested this unknowingly. Most cocaine intoxication, someone is taking the drug for wanting to get the effects, and so we would call it an accident because they didn't take it to try to kill themselves. In this case, police investigation did not show any history of illicit drug use. Everything that they found that as soon as she found out she was pregnant, she wanted to do everything she could to take care of herself and take care of that baby. And it didn't really fit with your classic using drugs for the euphoric effects and accidental death. It was much more suspicious that someone gave it to her without her knowledge, but it didn't have enough to get to that, homicide determination.
The defense says the evidence that led to that conclusion has gaps no one on this witness list can fully close. This case does not end here. The story does not end here. If you want to follow what happens when a jury gets handed a case with a broken chain and is asked to find it whole, stay close to this channel. The next hearing in this case will tell us whether the reasonable assurance the judge found today holds up in a room full of 12 people who do not share his training. That is where verdicts actually get made, and that is why we watch.